proceedings are quasi-judicial in nature. All decisions of the board will be based on competent, substantial evidence, including testimony provided at this meeting. Any person who is not an applicant or agent that wishes to speak will need to fill out a speaker's card located at the side table by the door and turn them into the clerk. Each member of the public will be given 3 minutes to speak on each item. Please refrain from speaking from the audience. Applause or cheering will not be allowed. Please silence your cell phone. Do we have a roll call, please?
John Moreland.
Here.
Owen Curley.
Here.
Jeff Schular. Todd Smith. Jennifer Williams.
Here.
Matt Metz.
Here.
Laura Tierney.
Okay, next on our agenda is approval of minutes. If everybody has reviewed the minutes for July 2nd and July 16th, can I have a motion?
I move we approve the minutes of July 2nd, July 16th.
My second.
Okay, it's been moved and seconded. All in favor?
Aye.
Opposed? Okay, the minutes have been approved. Is there any correspondence? No. There's no old business, so let's call our one case for new business. Oh, yeah, sorry. Well, let's call it and then we'll advise them.
I call case number BOA 24-10000036. I don't have to, can you give me? I don't have it. Thanks. Property address 1198 Beach Boulevard, parcel ID 177502-0050. Motion to consider sections 34-377 for 0 parking spaces in lieu of 13 new required spaces for proposed expansion of outdoor seating with a total size of 3,200 square feet, and 34-377 for a reduction in existing parking spaces by 6 total spaces along the western side of the existing structure to be converted into outdoor seating. 34-343E5 for 89% lot coverage in lieu of 85% for the removal of existing landscaping to accommodate the required 3 spaces for the existing approved outdoor seating of 800 square feet.
Okay, as a reminder, each member of the public will be given 3 minutes to speak when we open the public hearing. Does any board member have any ex parte communication?
I've had none.
None.
And I have none. Would the applicant please come forward to be sworn in and give a presentation? Actually, before you get sworn in, there are only 4 members tonight. You're entitled to have 5. With 4 members, voting members, you have to have unanimous consent.
There's 3, yeah, 3.
There's 3.
Yeah.
But you would have to get 3.
Yes.
The choice is yours. You can defer until we have 5 members, or you can be sworn in and give your presentation.
I'd like to go forward, although usually attorneys are not sworn in.
Okay, do you want to proceed?
Yeah, yes.
Before you call the case, I just want to mention that the proposed outdoor seating on the first floor will not add any water coverage. It's not asking for any water coverage. And although the total additional area proposed will be 3,200 square feet, the plan is to enclose some of the second story, so not all the proposed seating will be outdoors.
Yeah, is this different than what was advertised?
No, it's just something. He just stated because so he doesn't really need the
Okay. We have a court reporter. Is there any way to be spoken into the record?
Absolutely. Yeah, where's your court report?
Right.
Okay, great.
Yeah, he doesn't need any water coverage. That's all I'm pretty sure I'm saying.
Okay.
So, same lot coverage is all.
Yes.
Okay, sir, go ahead. Proceed.
Good afternoon, actually good evening, Zach Warner, 3203 Old Barn Court. I have a presentation. I wasn't sure if you have the PowerPoint. Thank you. This is for the property, it's actually 1198 Beach Boulevard. This is an out parcel and a shopping center. I apologize, the presentation actually said 1168. Just to clarify a couple of points, if you notice in the application, and as your staff did a good job repeating it, we didn't request a reduction in lot coverage. I wasn't sure why that was in there. Also, we're not eliminating 6 spaces, we're eliminating 3. And finally, it reads in the staff report that we're trying to do 3,200 square feet of outdoor space. We're not, we're approximately trying to do 750 square feet of outdoor space. So we're just here on the parking right now. What we're here for is actually pretty straightforward. There we go. Property is currently located at Don Beach Boulevard. It fronts on a FDOT right-of-way that, if you've grown up the beaches, you know is exceptionally wide and actually goes into the paved area part of the shopping center, but is actually in FDOT property. My client has entered into was effectively a 10-year lease for the parking area in order to apply for those approximately 38 spaces of parking to apply for the expansion of his out parcel. The property actually has 24 spaces currently on it. I can take that as an omen, the lights going out. Per your planning director, your senior planner, the current uses on the property only require 21 spaces on the property. We have 24. For the additional spaces of the additional uses that we want on the property, per your code, which is 1 space for every 250 square feet, we're required to have 13 additional spaces. Normally in this situation, your code under 34-375 allows you to get that approved administratively. And you can do that when the off-site parking is within 300 feet of the property, which we are. You can do that when it's in the same zoning as our property, which it is. You can do that when you have limitations on sign, which is not an issue. The problem is that portion of the code requires a deed restriction. Because this property is owned by FDOT, we cannot put a deed restriction when you're parking on public land. That's why we're here for the variance. That's the only reason we're here for the variance. We're not here to eliminate lot coverage. We're not trying to get adjustment. We're just trying to get the parking spaces that are next door to our property that would normally be approved administratively applied to our property. Again, we require 13 extra spaces and we're going to use 38 next door. And go through the requirements of your code. Your staff has already recommended approval of this. That is competent substantial evidence by law. I'm happy to answer any questions, but really, given the crowd here, I'd rather reserve my time for rebuttal. Thank you.
I do have one question.
Sure.
Before you go. I just want to step through our standards that are applicable to variances, just so that I make sure I understand what it is that is applying here. Can you address, first of all, the special conditions and circumstances which are peculiar to the parcel of land?
Certainly, because this property is against FDOT property, which cannot have a deed restriction on it, that is peculiar to this property. Anywhere else where this would exist, we could get this approved administratively. So this is property that's been parked on as long as I've lived at the beach, which is coming up on 45 years, and as long as anybody else has lived at the beach that I know of, this has been this way for 65 years. That's peculiar to this property. I've never seen that happen anywhere else at the beach's property. The lease allows us exclusive possession of it, so these parking spaces are ours whether this gets approved or not. We would just like to be able to use it to expand the current commercial uses on the property, which your comprehensive plan encourages infill development. So we think that plus the variance criteria is very important for you to consider.
Okay, the second one is special circumstances and conditions that do not result from the actions of the applicant.
Same thing. The property and the 65 years that this has been used as FDOT right-of-way was not created by the applicant. This is anywhere else in the city would just be a private property where we could put a deed restriction on it. It would be administratively approved. The fact that the FDOT right-of-way is, I think, over 200 feet in width was not a circumstance that was caused by the applicant.
And then 3 is granting the variance will not confer upon the applicant any special privileges.
There's no requirements in the comprehensive plan that give this as a special privilege. Again, this would actually be a privilege that would be afforded else, we're just asking to be treated the same. We can't because the property is public property.
I think you've already addressed the literal interpretation, which is number 4, and enforcement of the terms which deprive the applicants of the right to commonly enjoy their own parcels of land. 5 is the granting of the variance as a minimum variance. It will make possible the reasonable use of the parcel of land.
Yes, as I said, we're only for one space here, 250 square feet of additional commercial space and a shopping center would require 13 extra spaces. We're adding in 38 spaces by this variance. So this is well beyond what we need.
And 6 is granting the variance would be generally consistent with the purposes and goals and objectives of the comprehensive plan, which I think you've already addressed.
Yes.
Okay. Any other questions?
Just one. If we approve this, that basically helps your parking space issue. But if there's another tenant in the area, then they do not have access to these, or they do have access to these?
If you mean another tenant not on my client's property,
Yeah.
regardless of how you vote tonight, they would not be able to use those parking spaces. This is the lease that's exclusive to my client. So whether they get expanded or not, these parking spaces are for the use of my client and their tenants.
And no one else?
Correct.
At the start, you outlined some differences in terms of what your request is versus the request that was posted and that we received in our packet. I just want to make sure that we can clarify that, because what I anticipate happening for you here is we will amend the request to reflect what you presented this evening, which sounds like it's a lower request, so it would not require reposting, because anybody that had an issue would have already been here tonight or written in about it. But I don't want us to have to come up with that language on the amendment, so if you could restate what exactly you're requesting, just so that we can have that on hand, that would be helpful.
Well, I would just go to what's in our application. Our application doesn't speak to anything with lot coverage. It doesn't speak to anything about getting rid of 6 spaces. So I would go with just what's in our application, which is we're essentially asking for a variance to allow these 38 parking spaces to count towards our parking requirements on site.
And you said instead of 3,200 square feet, it was 750?
It's, the staff report is written a little awkwardly. The way I read it, it looked like we were going to do 3,200 square feet outside seating. We're not. We're going to do 750 square feet of outside seating. Now, to be very clear, for that outside seating, we still have to go get a conditional use permit. The total amount of square footage that we could possibly add on this from this variance would be 3,200 square feet. We might do less, but that's the total amount that we would add on this property.
So we would not be asking for 89% lot coverage
No.
instead of 85, so no amendment would need to include that. We're not asking for 0 parking in lieu of 13, we're asking to credit the parking in the FDOT section.
Yeah.
In essence, because we can't provide, or they can't provide a deed restriction on the DOT property, it can't be considered shared parking, so the only mechanism in the code is basically to reduce their required parking, knowing that they have that in the right of way.
If those spaces are not open to anybody else except your clients, customers, isn't that a unique and special privilege that's being given to you, not other people who are in the shopping center?
Through the chair to Board Adjustment Member Moreland, that's a privilege granted under a lease. That's not a privilege granted by the variance. That's just how the lease works. The lease grants you exclusive use of property. But thank you for the question. I think that's an important thing to make.
They have a 5-year lease and a right to renew in 5 years.
When does that, yeah, that was my question. So when does that lease expire?
November 2023. But if you read the lease at that point in time, if it wasn't renewed, it'd still be considered a tenant in sufferance. So it would still.
So it's expired now.
No, it's active now.
So
November 2033, sorry. It was November 2023 that was entered into.
And your outdoor seating is going to be 750 square feet.
Correct, but I want to be very clear, nothing that you approve tonight entitles us to the outdoor seating. We still have to get the conditional use. It's just, as part of this, where the outdoor seating would go, is where 3 existing parking spaces would go. So the total, we're increasing by 38 and decreasing by 3.
Any other questions?
Thank you.
Thank you.
We have issued instructions.
Through the chair, I just want to clarify that because this is a shopping center, their parking standard is based on a shopping center standard, not each individual use. So in this case, it's one space per 250 square feet. That's how that calculation works.
And our first speaker is Michael Orr. Michael Orr, please.
Please raise your right hand.
I'm also an attorney, but I have no problem swearing to tell the truth.
Okay. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
My name is Michael Orr. I'm an attorney at Orr Cook. The address is 50 North Laura Street in downtown Jacksonville, 32202. Good evening. Thank you for allowing me to present. I represent Southern Swells Brewery, Gusto's Italian Restaurant, 2 tenants in the Beach Plaza, the adjoining shopping center. And I also represent Tavis Investments, which owns the majority of Beach Plaza. And I'm here to make a couple of points on this.
Stop you
Yes,
just
sir.
for a second. My clock is
That's a special trick I have with it.
I like the light trick too.
Thank you.
And while that's getting resolved, since Mr. Orr got sworn in as a witness, I'm entitled to due process to actually cross-examine him on any items, so I'm requesting that right after he's done with his presentation.
And we would object to that, but that's fine. You can't be an attorney and refuse to be sworn and then say you can't be questioned.
Always use our phones.
Yeah, it's not showing.
And I object to him getting 11 hours.
I can talk that long.
And it's adding.
Also a special power.
It's getting better.
All right, we're all set. Sorry. Apologize.
No worries.
Whenever you're ready.
I'll wait for Ms. Lindy. Thank you, sir. So administratively, we do have a court reporter here today and who is present to my right. And we've provided binders with some of the competent substantial evidence that you'll hear some of the presenters talking about after me. I do want to give you sort of a background as to why we believe this should be denied. And I'm here following what I've seem to believe is a 10-year whack-a-mole regarding the parking at the Beach Boulevard Plaza. If you look into this file, and we've provided copies of variance denials in the past, where Ed Ashurian, the principal of Haste LLC, the applicant, has come before this board and others seeking for all sorts of variances and waivers with respect to this out parcel. I need to provide you some background information as to why that's happening and why this variance request should be denied because of it. Previously, Ed Ashurian owned the entirety of Beach Plaza. And at some point, he parsed this parcel out, and he lost the majority of Beach Plaza through foreclosure. But before doing so, he created a reciprocal parking easement between the two parcels, the Beach Plaza and the out parcel he now owns through Hastay, which was undeveloped at the time and had nothing but parking on it. And then eventually, after providing for the reciprocal parking, he sent a letter in 2018, which we provided to you, it's at tab 20, asserting that he had certain rights to the parking on Beach Plaza. He was asking in part to tear up outdoor seating for my clients, Gusto and Southern Swells, that he had in fact approved and arranged for when he owned the entirety of Beach Plaza. So now he's saying you need to take it out so I can have these parking spaces for my out parcel that I want to develop. He was claiming rights to those. And when they denied him, he sued them. And we provided some documents from that lawsuit. And that lawsuit went on for several years, arguing over the parking on this parcel that you're dealing with today. It was before the Circuit Court of Jacksonville, and it ended with an order granting our summary judgment as to our interpretation of the easement and denying Hastay, the applicant's interpretation of the parking easement out there. That's significant because during the pendency of that case and after they lost that decision on parking, they came back to you through the World of Beer application variance. That was the tenant that was going to take this space in the rooftop bar. When they, and I'm going to have one of my colleagues is going to address that World of Beer case and the issues that came out from it. Following, is the time up? All right, may I have 30 seconds to conclude?
Yes.
Just very briefly, they've ended up having to pay hundreds of thousands of dollars in attorney's fees and costs to us as a result of what they've done out here for this parking. And you're going to hear how they've overburdened us. And the theme tonight is everything that they're complaining about, they've created, Ed Ashurian has created. This isn't a special property because of FDOT spaces. It's special because it's being overdeveloped by its developer. Thank you.
Okay, our next, sir, you can sit down, please, and wait till the.
I'm just putting on the record the right to cross-examine.
No, you
Okay, thank you.
Our next speaker is Joseph Pickles.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Joseph Pickles, 50 North Florida Street, Jacksonville, Florida. I would like to touch on a little bit of what Mr. Ward was discussing when it comes to this World Beer. Specifically, I believe in the variance application as well as in the staff report, there's a reference to this pre-approved or existing approval of outdoor seating of approximately 800 square feet. This was based upon a prior conditional use application from World Beer. Essentially the request was to allow World Beer to use some of the rooftop space in this building in order to operate for this restaurant. I represented Tavis in a lawsuit against both Hastay, who's the owner of the property, and against World Beer, who is the conditional use applicant. A copy of that most recent complaint is in the materials, the binder provided to you at tab 5. And our claim was that the development order under that conditional use application was not a license to violate the land development code. Specifically, in order to accommodate that rooftop space, they were going to have to add an elevator as well as stairs on the exterior of the building, which was not calculated when it came to the lot coverage. And by adding those items, they were going beyond the 85% threshold. They never requested a variance. Also, there were parking issues, which, for example, one of the issues was their requirement of the land development code to have at least 3 ADA compliant parking spaces for disabled people. As it stands right now, there's no ADA spaces that are located fully on that property. And Mr. Newport is going to talk about that here in a moment. So, bottom line is they were well in excess of the 85% that they were going to have to accommodate in order to include the ADA spaces as well as the elevator and the stairs. It was going to be approximately 89% lot coverage, get no variance. What happened is SDA was trying to use this conditional use application's approval in order to piggyback and violate the land development code when they already had multiple denials of their request to go beyond 85% lot coverage. During the lawsuit, World of Beer went out of business before they ever opened the restaurant. A default was entered. That default was at tab 6 of materials. And once the default was entered, once World of Beer went out of business, essentially most of those issues in the complaint became moot. And the reason being is that the applicant, again, was World of Beer. And you can find the conditional use application in the materials, that's a tab 9. And the land development code is very clear that a development order for conditional use is not assignable or transferable, but is granted only to the applicant. Estate was not the applicant. They're nowhere on there, only World of Beer. So once World of Beer went out of business, that conditional use application went away. Estate cannot rely upon that to say, well, we have approval for outdoor seating. Currently, the lawsuit, it was administratively dismissed. There's a petition pending right now to reopen that lawsuit. But at the end of the day, it really doesn't matter because that conditional use application is no longer valid. They can't rely upon that to violate the land development code. Thank you for your time.
You want to call that I just want to clarify that the lack of variance when the conditional use was approved does not make the conditional use illegal. It just means if they exceeded the lot coverage, they would have to come before you guys to request that variance. But there's nothing about not having the variance that makes the conditional use illegal or incorrect.
Next speaker is Brett Newkirk.
For the record, we're submitting Mr. Newkirk as an expert, as a professional engineer to talk about these issues.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Brett Newkirk, 11329 Distribution Avenue West in Jacksonville, Florida, 32256. Good afternoon. Again, Brett Newkirk. My company is Alta Engineering. I have reviewed this project as an engineer with respect to the World of Beer application and just have a few comments for you guys, just as background information. Number one, I think it's already been discussed that the ratio of parking to square footage was used as 1 in 250. Obviously, the outdoor seating area that's going to be used will most likely be for a restaurant, and the World of Beer application that is also for the rooftop area is a restaurant. Normally, if this was approved for use as a restaurant, it would be a 1 in 100 ratio, so it would more than double the amount of spaces that were needed. I understand there's an issue with how it was originally approved, so that's one thing. Number two, I do have a report that's in your binders under tab 8 that kind of goes through some of the items that we reviewed in that regard. Number three, the 88 spaces that are shown that are on the front of the building here, there are 3 of them. They are all located in the right-of-way zone. Yes, sir.
Could you just get a little bit closer on that?
Yes, is that a little bit better? Okay, sorry about that. So the issue with the ADA spaces being in the right-of-way is the domino effect that would occur if those, if the right-of-way was ever taken. Because if you have to move those ADA spaces around the back of the building, it would necessitate the construction of a sidewalk in an area where you currently have pervious area. And so the extent of that sidewalk installation would significantly detract from the pervious area. I realize that now I now understand that pervious area is not an issue here, but there is going to be that effect on the project once, or if that were to have occurred. And when you bring that sidewalk around the back of the building, it already has a drive lane that is too narrow. And it's not, it's actually narrower than it's shown because the curbs of the adjacent property parking islands encroach upon it. And if you were to add this sidewalk, that would be taking an additional probably 4 to 5 feet away, further narrowing the drive lane to probably around 14 feet or so. So that's all I have.
Maybe I'd like to reiterate for the record the right to cross-examine this witness.
Just to clarify again, future. NDA is not on the agenda tonight, and not what you're considering. It's speculative, and we have no evidence that it would be needed. If it did, it would come before you as another variance.
Okay, next speaker.
Next speaker is Randall Whitfield.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and your address.
I'm Randall Whitfield, 7880 Gate Parkway, Jacksonville, Florida. Here representing the Tavis Group. What is Hastay's hardship? It's lack of parking, too much lot coverage, and now they want to add more usable square feet. Hastay has just simply built too much building on the site that they have. Let's go back just a little bit. Hastay's original code requirement for the original 12,000 square feet they built was 48 parking spaces, for which they only provided 16. We're in the other 32 spaces. Then Hastay wanted to add 800 usable square feet to the roof, requiring another 3 parking spaces. And I know there's been confusion on what's actually being asked you to decide on. But according to the staff report, and that's the only thing I can go by, Hastay now wants to create another 3,200 square feet of usable spaces, requiring another 13 spaces. Now that makes their total building requirements of 48, they're short by 48 parking spaces of what's required for their building and their uses. All these shortages are Hastay's own creation. So Hastay has created their own hardship. The lease with FDOT right-of-way is only for 13,000 square feet. That will not accommodate very many parking spaces. And that lease is cancelable with 30 days notice. What will happen then if that lease is canceled? I've never been able to count any parking spaces within the FDOT right-of-way toward my parking requirements. The planning department has always told me I could only count the spaces within my property line. To grant this variance would be detrimental to the neighboring property owners, who would have to shoulder the burden of Hastay's shortage by supplying Hastay parking on the neighboring owner's own property. At Beach Plaza, we strive to bring quality tenants, and our critical elements to doing that are our location, our visibility, and ease of ingress and egress, but parking is a problem there. We've lost tenants like Winn-Dixie. We had a parking field and number of space issues. Harbor Freight, we had parking issues with them. Eliano's, an out parcel for coffee, we could not accommodate because of parking. And the lot coverage variance, the board has turned Hastay down many times, at least twice, and yet they keep coming back. Again, this is a hardship that Hastay has made itself and is of its own making. Thank you.
Dave Bowman.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I can.
Please state your name and address.
Okay, my name is Gabe Bowman. I'm here, 7880 Gate Parkway, Jacksonville, Florida, 32257. I'm here representing H&H Enterprises, otherwise known as Beach Bowl, which I'm sure you guys have seen down the road. We started this remodeling project at 818 Beach Boulevard in 2019. Upon the first review of our site plan, it was brought to our attention that we would be required to submit for a variance that's for the site, and that we would also not be allowed to use the parking we had designed on the new site plan that was in the right-of-way, and that they would not count towards our overall parking requirement. We were told that there was no way to include these spaces at all. Why should Hastay be allowed to use these spaces towards their new proposed use? This option was never offered as an alternative to H&H Enterprises. We were never offered to be able to pay for these spaces with a lease from FDOT. Multiple modifications had to be made to our site plan to accommodate as many spaces as possible to count towards our required spaces needed. These modifications we have met. We also got our variance approved with multiple modifications. H&H Enterprises does not see any accommodations to Hastay's site plan to accommodate for this additional square footage, which I still have a question on how much is that? Because there's a very big difference between 750 and 3,200. The additional parking needed for Hastay's expansion of this existing building square footage it all appears to be off-site, with very little to have been to the proposed site plan of the existing site. H&H Enterprises does not agree that BOA 24-10036 should be approved. Thank you.
Excuse me, Ben Perry?
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Ben Perry, 7880 Gate Parkway, Jacksonville, Florida. Good evening, board members. Thank you for your time this evening. To touch on a couple things we've spoken about in this hearing, the first is the FDOT lease. And I want to draw your attention to the temporary nature of this lease. That lease is actually in your packet tonight. In section 1, it talks about property and term. The term of that lease is 5 years. It grants a 5-year option. There's no assurance, though, to renew that lease after that point. If a tenant at that shopping center would go beyond that term, there's no assurance that the FDOT lease would be extended. Section 2, the use. The lease states that the leased property shall be solely used for the purpose of parking and access. There's historically been a food truck on that property, and that would in itself violate that section of that lease. Section 3 is rent. Lessor reserves the right to review and adjust the rental fee biannually and at renewal to reflect market conditions. If the applicant were to not pay the renewal every year, or if that lease were to be renewed and the rent went up, and the applicant did not pay for that, they would be in violation of the lease and could be revoked at that time. Section 5, maintenance. Lessee shall keep and maintain the leased property in good and safe condition repair at lessee's own expense during the existence of the lease. If the applicant did not keep up that property in an orderly manner, the lease can be revoked. Section 9.a. This lease may be terminated by lessor immediately without cause upon 30 days prior written notice to the other party. Once again, a temporary lease. Section 9d. Lessee shall not assign this lease without the prior consent in writing of the lessor. If the applicant were to sell that building, there's no assurance that FDOT would then assign that lease to the new owner. And in the addendum, in the back of that lease, it states that upon termination of this lease, there should be no striking for parking or other private improvements remaining in the FDOT right-of-way. So once the lease is terminated, the applicant will lose all rights to even strike that parking area. There will be no parking remaining. Second thing that we've spoken about is the parking. This is truly off-site parking. And in your land development code, it requires that the applicant have a deed restriction. And the intent of that is really to create a permanency of that lease so that the city can rely on something that's permanent and not temporary. One other item is that we have over 15,000 square feet of vacant area in our shopping center at Beach Bottom. Parking is always a major issue there. If you go at certain times of the day, the parking lot is full and you cannot find any parking. The applicant's proposal would create another bit of harm on that parking area, and there wouldn't be enough parking. Thank you for your time.
J. Michael Trainer.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address.
Michael Trainer, 818 North Palm Beach Boulevard, Palm Beach, Florida. Members of the board, I just have a couple things to say, and I'll be brief. Okay. One, and this goes, I think, Chairman Curley, you asked some questions at the beginning about the standards. I think the first thing is the standard. First standard is whether or not it's a condition that's special. Okay. It's not. This building was built purposely the size it is. It purposely took up an awful lot of the space of the land of the parcel, and it's a creation of the owner. There's nothing special about it that wasn't created or could have been seen at the time. So I think it violates standard one. Standard two is whether or not it's the result of the actions of the owner. Same thing. They designed the space, they created the size, they designed the parking, they came to the board and asked for a variance, they came to the board and asked for conditional use, they got that. They were satisfied. Now they're not satisfied. But they made the problem. Not the city, not the size of the land. They created the problem. So I think this is standard two, which is it the result of the applicant's own actions? I think it is. The third thing deals with, whether it has an adverse impact on the adjacent land. You've heard already from other testimony that it has impacted the parking on the neighboring property. Your condition 6, I believe, Chairman Curley, it deals with whether or not it has a negative impact on the adjacent property. It does have a negative impact. But let's look at the easement for a minute, or the lease rather. The lease is taking up spaces that the general public could use. It's having a negative impact on the public's use of those spaces. Anybody can park there. Now, only people that they want to have parked there. Not to mention the fact it's an illusory lease anyway, because it could be canceled with 30 days notice. So I think that has to be taken into account too, as a negative impact that's being created by this variance. So for those reasons, that it fails to meet conditions 1, 2, and 6, I would ask the board to consider denying the variance application. Thank you.
Zach Miller.
That's me.
Okay.
Mr. Chairman,
Yeah.
recent points.
Good evening, board members. David Miggett, City Attorney. Wanted to bring to your attention, our code does not have specific procedures for quasi-judicial hearings other than the minimum requirements of state law. But one aspect that's at issue here, I think, and I'm going to defer to you all, is because we don't have those procedures, there's no way for an interested party to what's called intervene or become an intervener. And that's important because under state law, an applicant does not have a right to cross-examine a member of the public, but they do have a right to cross-examine an intervener who testifies, or someone who testifies on behalf of an intervener. So I'm going to leave that up to you, but procedurally, erring on the side of if you choose to err on the side of caution, which I'd recommend, but you're not required to do so, you may want to request or allow cross-examination up to 3 minutes of anyone who spoke. to ensure that the applicant's procedural due process rights are met. I could gladly clarify if I'm not doing a good enough job of being specific. And before, just two other things before I forget to mention them is, if you do so, anyone who's already spoken is deemed to still be sworn in. There's no need to swear them back in. And then lastly, I was in a city council briefing. I apologize for arriving tardy, but because I arrived tardy, I did not see whether you all made any ex parte disclosures or noting that you had none.
We had no ex parte.
Then we need to disclose that for the record before the hearing's done.
We did.
Oh, you did. I'm sorry. I just wasn't here at the time, so I wanted to clarify that. So you all could discuss it. I'll gladly answer any questions to the extent they're legal, but it's kind of a gray area because we don't have a procedure where someone could qualify as an intervener, but they're acting in the fashion of an intervener. So I guess I would recommend cross-examination, but I would defer to you all.
Okay, thanks. Why don't we take a moment to discuss whether or not we want cross-examination. It's been our practice not to have cross-examination of public that testifies, but I'm open to suggestions.
I would prefer to have cross-examination. I think that there's a lot of people, a lot of money, a lot of time that's gone into this, and I would rather err on the side of caution and allow for 3 minutes each.
We didn't examine anyone, they gave testimonial. Our procedure is such that the applicant can come up and address any and everything that has been brought to the table. There's no time limit on his ability to do so. I don't see any reason that you would need to call back the people that already presented their case. You can address the points. This isn't a legal proceeding to that effect. It's a board hearing. We've gotten the information from those people. He can address everything that was brought forward. That's consistent with how we've always done it. And we didn't examine them. We didn't probe them for information. I don't see any reason to have somebody else do so.
We haven't done that in quite some time, and it was by agreement. We agreed not to question the testifying public. Just throw that out there. Go ahead, John. I'm sorry.
No, I agree. I think that the applicant has an opportunity. I think that the applicant has an opportunity with unlimited time to respond to the testimony of the other presenters. And I don't see value in having a cross-examination. So we're staying with the procedure as we normally use it.
Okay. So, in light of our normal procedures that we use, we don't question the testifying public. City Council, or the Council of the City, has recommended that we allow cross-examination, but our problem is, who is a quasi-intervener? Who is the public testifying? We have business interests, we have business owners, we have attorneys representing various businesses. And so I think we're going to stick to our normal procedure, which is we don't permit the applicant to cross-examine, and nor do we cross-examine the testifying public. And that's why we limit their testimony to 3 minutes. With that, we would invite the applicant back up to address any of the points made and any other questions that the board would have. And just for the record, we did do the no ex parte communication. Sorry.
And just to clarify for Mr. Leary, there was ex parte disclosure, but nobody had any ex parte.
Right.
Yeah, not that you didn't, nobody know. Yeah.
We disclosed that we didn't have any.
Yes.
Communication.
Is that
we would do it at that time. So just again, our procedure is before it's called, do you have any ex parte, or right after it's called, do you have any ex parte communication? If a member did, then we would disclose it at that time.
Oh, I understand.
And every once in a while, someone will call or someone will
Oh.
talk to you.
I understand. I just want to make sure, because there's a court reporter here. It sounded like you said we did not do ex parte disclosure. I think what it meant was there was no ex parte to disclose.
That's right, I'm sorry, I'll stick that again. We polled the board as to ex parte communication, and no board members indicated that they did have ex parte communication. Sorry.
All right, again, Zach, I'm going through 203 Old Martin Court. I really appreciate the board entertaining some of the objections. Understand as an attorney, I have to put those on the record for any future court matters. You heard a lot from Mr. Orr about a court case that respectfully doesn't have anything to do with this. There was a building permit issued 2 years ago, and Mr. Orr's client, it was the owner of the shopping center, I guess they liked the competition, and decided to sue, saying there wasn't enough parking on the site. Well, your staff is inclined and issued the building permit, but there isn't. If you look at the image, there's 24 spaces on site. That's enough for the current rights. On the lot coverage, staff issued the building permit. We meet the lot coverage requirements. Again, just to reiterate, because I know there's some confusion on this, we're not asking for any lot coverage variance. By law, your staff report is competent substantial evidence as to this variance. You heard a lot of talk from Mr. Pickles about the conditional use. The conditional use was for World of Beer. That is not why we're here today. For the outdoor seating for the restaurant, it's actually on the previous slide, you can see it on the western portion of the property. We'll have to come back for the conditional use for that to be granted. This is just whether the parking spaces we leased can be applied to increasing the square footage for this property. Your comprehensive plan and your code speak to infill development and more commercial uses. From everyone in opposition, all I get here is that they just don't want any competition in this area. That seems to be the main reason why they're here objecting. We have these spaces. This variance is not going to change it. Nobody else can use them while our lease is valid. If they cancel the lease for some reason, I think they'd be on the hook for some damages for canceling it. However, if they did, then the certificate of use would probably have to be revoked for that property that's using them. Again, the 3,200 square feet is not for 3,200 square feet of outdoor space, it's just for expansion of this property. That 3,200 square feet requires 13 parking spaces. We're talking about an addition of 38 parking spaces in property right next door. And the only reason that this couldn't be approved administratively is because we can't put a deed restriction on it. As to the requirement, the issue of the width of it, and what if FDOT took the property? I grew up at the beach, my parents grew up at the beach, right at 19th Avenue. When I moved back, it was at 5th Avenue. This is approximately 160 feet wide of right-of-way. I don't see FDOT 10-laning Beach Boulevard anytime soon. I don't think it's going to be taken, but if it did, then the variance goes away. It's conditioned on the lease. We're just asking that you follow your staff report, which is competent substantial evidence as in the requirements, and allow us to use this property that is right next door for our parking needs. Thank you.
I just have one question for you.
Sure.
There was a gentleman who addressed the 6 standards applicable to all variances, and I'm wondering if you could maybe comment as to his comments.
Sure. I was a little confused as to his adverse impact comment, because I don't see that in any of the requirements. But if the complaint is we don't have enough parking, then exclusively leasing spaces should help with that. As far as criteria, number 1, special conditions and circumstances, your staff specifically found that we meet that criteria. That is competent substantial evidence. With all respect to Judge Traynor, who I respect very much, what attorneys say is not evidence. It can't be. What your staff says is evidence, and that's a matter of law. You can ask Mr. Lane that. On number 2, the special circumstances and conditions that do not result from your applicant. Again, your staff addresses this. That is competent substantial evidence. 150 feet, that is never going to be expanded beyond the current usage. Your code allows you to do this. As far as the deed restriction, putting it in place permanently, respectfully, that's not what the code says. People lease property all the time and put a deed restriction during the course of the lease that limits it to parking. The whole point is that when it's used as parking, you don't want to then have it be used as something else. This is not going to be used as anything other than parking. That's what that requirement's for. I'd love it if the city council would readdress the provisions in the code to deal with it, but unfortunately it doesn't. So the only way we can get forward with this is a variance.
And just to be clear, I'm
3,200 square feet of additional space. It's not parsed out between the two. If the board has a problem with that being too much, we can talk about reducing that amount. But again, that amount of space under your code would only necessitate 13 extra spaces. We're talking about 38 extra spaces.
I'm confused because you keep talking about, first you said 3,200 square feet wasn't relevant and that it was 750, and now you keep going back to 3,200. I really need you to flesh that out for us.
3,200 square feet of outdoor.
Mm-hmm.
The staff report read that there was going to be 3,200 square feet of outdoor space. We're only doing 750 square feet of outdoor, of the 3,200 total. So it'd be 2,450 added up to, and then of that.
Where's the 2,450 going to be?
It would be on the roof.
The rooftop?
Yes. And that would be the maximum. If you can, it's hard to see on the zoom in, but you can see the, no, you really can't see. The 6 shaded in spaces on the western part, if this goes through, we'd be eliminating 3 of them on our property, and that's where the outdoor seating would go. So I apologize for the confusion, but I want to clarify that the staff report read that we were doing 3,200 of outdoor space.
So why would we even mention 3,200 if 2,250 is actually on the rooftop, and that's not relevant? I don't think that's relevant here, Christian. Because the only thing that would be relevant, I think, would be the 750 that's taking up additional area.
I think the confusion comes in any additional added square footage has to be accounted for. So the 750 square feet as outside seating versus 2,500 square feet, or whatever the number is,
Just the
inside
parking
seating,
space calculation.
it still counts it's the same at 250. So however they choose to divvy that up doesn't really matter. The only question is how many square feet are they asking for relief of parking from? In this case, it's 13 spaces maximum.
And the only reason we bring up the outdoor space is because we want you to understand that we still have to go get the conditional use for the outdoor space seating.
Right.
So,
Can you explain on the lease, because I was concerned, originally I was concerned by the fact that it's just 10 years, but I am more concerned since it was mentioned that it's cancelable in 30 days notice, and I looked it up, and it's paragraph or section 9 of the lease agreement that basically says that it can be terminated without cost by either party within 30 days written notice.
that's standard language in FDOT leases. Having done numerous FDOT leases over the past 16 years, I've never seen that clause exercised. If for some reason it was, then any certificates of occupancy or certificates of use that use these extra spaces would have to be revoked. I'm confident though, and my client's confident that it's not going to happen.
Going back to the standards applicable, I'm gonna read to you standard number 5 and just ask that you can help me address how this meets standard number 5. So that is by granting this variance, that would meet the minimum variance required to make possible the reasonable use of the parcel of land. So looking at what reasonable use the land can have and how this variance would meet the minimum requirement to make any reasonable use of the land.
Yes, through the chair to board member Mertz. Again, we're talking about 38 spaces for where we're required to have 13. The reasonable use of this property under your FAR standards is way greater than what we're asking for. This property is, I think, 30,000 square feet. I think the current building is approximately 12,000 square feet. This is only going to add another 3,200 square feet to the property. The minimum variance requirement for this would be if we did 13 spaces in the FDOT right away for 13 spaces needed. We're doing 38.
I just want to make sure that we're interpreting 5 the same way, which is not what is the minimum variance to achieve what you're trying to use the property for. It's what the minimum variance for any reasonable use of the parcel of land. So if you could help me close the gap between the current use and what is required to be reasonable use through this variance.
In that case, I'm just going to read into the record what your staff wrote, which is the only competent substantial evidence you have in front of you. Staff does find the requested variances are the minimum variance needed to accommodate outdoor seating. Although the shopping center has several tenant spaces which are occupied, the proposed site is the largest anchor site in the building and has remained vacant for many years. This is in part due to the constraints placed on the property by its irregular shape, but also the LDC not providing a means to account for parking in the FDOT right-of-way. It said DOT, but I knew the largest in the structure. The applicant cannot expect a reasonable use of the shopping center's entirety, and the proposed variance does not result in any change in the site. Rather, it is giving credit for improvements already made by the applicant. That's what your staff said. By law, that is the only competent substantial evidence you have as to .5.
Any other questions? Anybody have any other questions? No. Okay, sir, you could sit down. Is there anyone in the audience who has not filled out a speaker's card that wishes to speak? If so, please fill out a speaker's card. No. Seeing that there's no more speakers, I'll now close the public hearing and bring the item back to the board for discussion.
We have letters.
Oh, sorry, there are letters. Go ahead.
Chair Curley, I was just, for the record, I understand that we only got 3 minutes. I was going to make the request for additional time to respond to a couple of things that were said, but I understand that's typically not permitted. So if that's denied, it's fine, but I have to make the
Yeah,
request.
go ahead, make your,
May I respond to a couple of things that were said by council?
no.
Thank you so much.
We have a couple letters, sorry, before I close it.
And actually, one of them, I'm not sure if it's, I don't know if this was a mistake that someone gave this to me.
That's all I have.
Okay. Well, the first one is, my name is Tonino Di Bella, and I guess they're related to Gusto, and I operate a business at the Beach Plaza in Jacksonville Beach, Florida. During my time at the Beach Plaza, parking has always been an issue. Since the development of the Beach Plaza out parcel at 1198 Beach Boulevard, our business has experienced significant issues with parking. The parking lot is regularly full, especially in the evenings and weekends. Allowing more development in our already overcrowded plaza would be a detriment to my business. I understand that the Beach Plaza out parcel continues to seek variances and waivers related to parking so that they do not have to provide adequate parking for their own development. This overburdens my business, and I object to any variances or waivers related to parking at the Beach Plaza out parcel. The second one, I'm not sure how it's relevant, I apologize, but this one appears to be from Andrew Hoffheimer to Bobby Brown, commercial leasing agent, and it says, "We like it. HFT liked the location of the site before, but just couldn't make the elbow work due to the parking. I've set the wheels in motion. We'll keep you updated." I'm not sure how that's relevant.
May I advise that Mr. Perry, when he spoke about the square footage that isn't being leased on the Beach Plaza property because of parking issues, that was one of the submissions from his testimony.
Okay.
They were trying to get a Harbor Freight in and they wouldn't do it because there wasn't adequate.
Okay. That's all I have.
Okay, I'll now close the public hearing and bring the item back to the board for discussion. Is there a motion?
I make a motion to approve BOA-24-10000036 based on the testimony and evidence provided. The request has met all the standards for variances outlined in section 34-286 of the Land Development Code.
Is there a second?
Second.
Okay, it's been moved and seconded. Discussion?
I think if we're gonna consider it at all, it would have to be limited to that lease agreement for certain.
Conditions of the lease
Yes.
agreement? Yeah,
I mean, if at all, there's a consideration that it definitely has to be. So I don't know if we should do that at the beginning in the motion. We should vote on that, and then, motion to approve of BOA 24-100036, to be conditioned on the continuation of this lease agreement for the variance that's been requested.
Okay, is there a second?
I'll second.
Okay, any discussion on that?
Well, that removes my biggest concern, which was the 10 years and the 30-day termination clause in the lease agreement. It just seems to me like this was a creation of the developer I can't really, we got this very late, and it's a lot, so it took me quite a long time to figure out who the parties were, but it looks like it was all initially owned by the same person who created two LLCs and separated the lots. And now it looks like parcel B is even owned by somebody completely different. But it just seems like this was a creation of the original developer, and there's just not adequate parking. But it's not unique, except for the fact that it was created.
Okay, so, we have an amendment to the motion to make it condition on the, FDOT lease. Any discussion on that? No? Okay, can we have a, roll call vote on the amendment to the motion?
And yes vote is?
Yes is that you agree to the amendment.
That it's limited to the lease agreement.
Don Moreland,
Yes.
Jennifer Williams.
Yes.
Matt Metz,
Yes.
Owen Crowley.
Yes. Okay, so the motion is now amended to make it condition, on the continuation of the FDOT lease. So, can we have discussion now on, the pending motion? Anyone?
I just said fine.
There are a lot of things to consider,
Yeah.
and so in the interest of time, I will keep it to the simplest one for my brain to control a little bit of, which is, what is the reasonable use of the parcel of land, building, or structure? And I think the applicant spoke to their interpretation of that and what exists, but to me, an expansion of space for limited parking does not create a more reasonable use of a property if the constraint is that there's not sufficient parking for the existing use to be successful. So I don't see tying an expansion of additional outdoor space as addressing the underlying need that was described by the applicant for the existing structure. I think we have a structure in place and that it has the conditions that it has. It, to me, appears to be a reasonable use. Whether or not they found the right tenant to make that profitable is not really for the board to consider. But nothing about the request that I've seen today suggests that this is creating a minimum variance to exact a reasonable use from the parcel of land or existing structure.
Yeah, there's been reasonable use of land for a number of years.
I'll step through the six standards because I think that all the parties here deserve to understand my thoughts, at least, on the standards that we apply and we're required to apply in granting a variance. And one is the special conditions or circumstance that are particular to the parcel of land. I think that we can all agree that there is special circumstances to the land, the shape of the land that's been pointed out in the staff report, and that does qualify, I think, as a special condition. But we have to consider all of them, and they all have to be yes. So on two, the special circumstances and conditions that do not result from the actions of the applicant, I struggle with this. I there's no precedent that we set. But I do remember Beach Bowl, and I do remember that they didn't have the right from FDOT, they didn't have this lease from FDOT to use those spaces. However, they were allowed to use those spaces, and I think that we agreed, and I may be wrong, that in allowing the landscaping in the parking lot, which is beautiful, that we recognized that they would park in that FDOT right of way. But they did not have a lease. They didn't have a lease. As for 4, the literal interpretation and the enforcement of the code would deprive the applicants of rights commonly enjoyed by other parcels of land in the same zoning district. I think he's enjoying those right now. I don't know that, condition would be no, because he's enjoying it now. I agree with Matt on 5, that the granting of the variance is not limited to variance that will make possible the reasonable use of the parcel of land and structure, because it is being reasonably used right now. And then 6, I do think, though, that the granting of the variance would be generally consistent with the purpose, goals, and objectives of the comprehensive plan. I don't think that there's any argument there. So we're supposed to consider all 6 of these. I think 4 of these are yes in favor of the applicant, or 2 of them, 2 and 5 specifically, are the ones that I find to be not in the applicant's favor.
Roll call.
I'm in agreement with you on 2 and 5. And I think Matt articulated it well, so.
Great. So strange. Okay, any other discussion? Okay, then I will ask for a roll call vote, please. And it is on the amended motion. So a yes is approval of the amended motion to approve the variance, and a no is not to approve the variance.
Jennifer Williams,
No.
John Moreland,
No.
Matt Metz,
No.
Owen Crowley.
No. Okay, sir, your request for variance has been denied.
Thank you.
Okay. I lost my,
No, you're not.
oh, can I have my agenda?
Oh, yes, well, let me remember that.
No, just the,
Yeah, I think it's,
I don't know, I got it.
oh, you have it.
I got it. Okay, so no, I got it. Okay, so, planning department report?
Our next meeting will be on August 21st, and we have 3 items on the agenda. Also, we'll be having our LDC workshops coming up this month. Our public workshop for LDC will be on August 14th. Board members will be on August 22nd, and then for council will be on August 28th.
So which one is first?
The one on the 22nd of this month.
The 22nd.
Yes, sir.
And then, next on our list is the courtesy of a Ford